Okay, let's dive right into this. Welcome to this explainer, especially to all you future lawyers out there. Today, we're unpacking the foundational architecture of global legal systems. Because look, when you step into a courtroom, the rules of the game, they literally dictate everything about your job. We're going to explore the two dominant blueprints for dispensing justice worldwide, the adversarial system and the inquisitorial system. And getting a grip on the bedrock of these systems isn't just some academic exercise. It completely defines your future role as an advocate.
Here's our syllabus for today. First, we'll look at the two paths to justice, then step into the adversarial arena, followed by the inquisitorial investigation. After that, we'll put them in a head-to-head comparison, and finally, weigh the pros and cons. Let's get to it.
All right, Section 1, Two Paths to Justice. Now, before we get into the nitty-gritty differences, we really have to recognize what these systems actually share. So both of these adjudication models have the exact same ultimate destination, right? Dispensing justice. But honestly, that's where the similarities end. The procedural road taken to actually get to that justice changes absolutely everything about how a courtroom operates. It totally dictates the roles of the judges, what you do as a lawyer, and exactly how evidence is brought to light.
So here's the high-level contrast. On one side, you've got the adversarial system. Think of this as a structured clash, two opposing parties presenting their cases to a totally neutral judge. On the flip side, the inquisitorial system relies on a judge who plays a highly active role in actually investigating the facts. Opposing parties versus an active investigator. Keep that fundamental difference in the back of your mind as we break these down further.
Okay, let's move into Section 2 and look at the system you're probably the most familiar with, the adversarial arena.
In the adversarial system, the whole process is entirely party-controlled. Each side basically develops its own theory of the case, and because of this, the lawyer, that's you, takes on the dominant role. You're the one out there investigating, gathering the evidence, and making the arguments. The judge, well, they take a much more passive role. And finally, there's a heavy dependence on procedure here. The emphasis is strictly on procedural fairness, making sure both sides have an equal opportunity to fight their battle.
And this quote brilliantly illustrates the whole dynamic. A neutral judge who acts more like a referee. The judge isn't there to actually play the game. They're just there to make sure you, the lawyers, are following the rules. They decide the case based strictly on the evidence and the arguments that the parties choose to present. If you don't bring the evidence, trust me, the judge is not going to go looking for it.
Geographically and historically speaking, this model is the absolute hallmark of common law countries. We're talking the United Kingdom, the United States, Australia, and India. If you're studying law in any of these jurisdictions, this party-controlled arena is exactly where you'll be practicing.
But what happens when we zoom out and look at the rest of the world? Let's get into Section 3, the inquisitorial investigation. This is the adjudication model of civil law.
To really grasp this system, you have to look at its roots. The inquisitorial system is derived heavily from Roman law and the Napoleonic Code. These historical origins shaped a completely different philosophy about how a state should actually go about finding the truth and dispensing justice.
It's often referred to as the interventionist or investigative model, and it's defined by a judge who, well, really takes charge. The judge plays a super active role in investigating the facts and determining the outcome. They aren't just sitting back in their robes watching the lawyers duke it out, they are actively out there seeking the truth themselves.
So the crucial point here is how this entirely shifts the power dynamics in the courtroom. It's a highly judge-centric process. Because the judge is the one doing the heavy lifting of the investigation, there's way less reliance on lawyers. Your role as a lawyer here is secondary. You're there to assist, but you definitely do not control the case. The judge controls the evidence, and because the judge is primarily the one questioning the witnesses, there's vastly less emphasis on adversarial cross-examination.
You'll find this model adopted primarily in civil law countries, or looking at nations like France, Germany, Italy, and Spain. They all operate under this inquisitorial framework. Moving on to Section 4, comparing the two systems. Now that we've defined the basics of both, let's put them side by side to really understand how those power dynamics flip.
Okay, let's break this down. When it comes to process control, the adversarial system is party-controlled, while the inquisitorial is judge-centric. Looking at the judge's role, in common law, they're a passive referee. In civil law, they're the active investigator. And finally, your role, the lawyer's role, is dominant in the adversarial system, but secondary and merely assistive in the inquisitorial system. It's fascinating. The procedural power perfectly flips depending on which courtroom you walk into.
And this power flip is probably most obvious in how evidence is actually handled. In the adversarial model, you, the lawyer, collect it, present it, and honestly try to tear apart the other side's evidence through cross-examination. But in the inquisitorial model, the judge decides exactly how and what kind of evidence, whether that's oral or documentary, should be presented. The judge questions the witnesses. The control over the facts is tightly held by the bench.
Let's move to the next point and see how this builds a very specific job description for the adversarial lawyer. Step 1, investigate. Step 2, collect the evidence. Step 3, present your arguments. And Step 4, cross-examine the opposing witnesses. The entire procedural burden rests squarely on your shoulders. If you fail at any of these steps, your client loses, regardless of what the actual truth might be. Talk about pressure, right?
Which brings us to Section 5, weighing pros and cons. Because look, neither of these architectures is perfect. They both have some really distinct benefits and some pretty significant flaws. Let's kick things off with the advantages of the adversarial system. First off, it highly promotes impartiality because the judge is entirely neutral. It ensures fair trial rights, meaning everyone gets their day in court to argue their case. It also relies heavily on strict rules of evidence, which definitely enhances reliability. Plus, it encourages immense legal expertise and adheres strictly to due process, which greatly reduces the risk of judicial bias. However, the dark side of this party control is pretty severe. It is incredibly expensive and time-consuming because of all that procedural complexity. And since lawyers dominate the process, justice can sadly depend on the quality of legal representation, meaning it heavily favors the wealthy. Furthermore, a passive judge can intervene, even if a blatant injustice seems to be happening right in front of them. Add in a high risk of witnesses being manipulated during those aggressive cross-examinations, and a judiciary that's often overburdened by prolonged, combative trials, and you've got some serious drawback.
Now, what's really interesting about this next point is how the inquisitorial advantages directly answered those exact flaws. Because the judge actively seeks the truth, there's way less scope for lawyers to manipulate the narrative. And by removing the lawyer as the dominant force, the system becomes significantly less costly. It often leads to much faster dispute resolution, and it's exceptionally well suited for cases that require highly detailed, objective fact-finding.
But of course, the inquisitorial system has its own critical vulnerabilities. Consolidating all that power carries an immense risk. There is a real danger of judicial bias because the exact same person performs both the investigation and the final judgment. It totally undermines party autonomy and adversarial rights. As a lawyer, you have a very limited scope to defend or challenge evidence. There's also just less transparency in how evidence is handled by the judge behind closed doors, which leads to a reduced emphasis on procedural fairness compared to the common law model. So, we are left with a fundamental clash of legal philosophies. One prioritizes procedural fairness and the clash of opposing parties. The other prioritizes an active, state-led search for the objective truth. As you prepare to enter the legal profession, I want to leave you with this question. Which architecture truly builds a fairer system of justice? Is it the neutral referee or the active investigator? Think about that as you continue your studies. Thanks for joining me on this explainer. Keep analyzing, and I'll see you next time.